event of the year for the FIU newly formed Heterodox Academy chapter. So we're glad that you're here. I'm Joseph Lichter. I'm a professor of chemistry and also the director of our pre-health office and a co-chair of this new formed Heterodox Academy chapter. For those not familiar, the Heterodox Academy is dedicated to strengthening academic life through viewpoint diversity, open inquiry, and constructive disagreement. The approach doesn't require agreement. It asks for curiosity, intellectual humility, and a commitment to evidence-based civil dialogue because as our slogan goes, great minds don't always think alike. Just briefly about how we started our chapter here, a colleague of mine and I were invited to a Heterodox conference last January in California because of some work that we had done in the sciences that was a bit controversial, but the conference was about censorship in the sciences, and I had not really been informed much on Heterodox until that event. It's free to join for academics. All you do really is go on there and join. And when I joined the chapter here at FIU, I realized I was a chemist and there was members already in the Heterodox Academy, including Iqbal from religion, Tori Arpad-Kata from art history, and Lindsay Maxwell from history. And so we started by just having lunches together at the faculty club, having conversations about issues with viewpoint diversity in our classrooms. And they were great. The lunches were always really fun. We would invite friends and we had these great conversations. And so we put together a proposal to create a community here. We want to get more faculty and staff that are interested in these kinds of topics to get together. I should say that at the same time that we were doing this, there was starting to become some initiatives from top down, from the administration, kind of talking about viewpoint diversity and free speech, which sort of changed the framework of what it meant a little bit. It sort of, some people may have felt that the term became more political. And so I just want to emphasize that we started as a faculty, bottom up, because we really do believe that in our classrooms we need to have our students understand viewpoint diversity and speak up if they don't feel in agreement with all the classmates that they have, and do it in a intellectually humble and curious manner. So the conversations format that we have today is a panel format designed to put the principles of the Academy in practice. It's not a debate, it's not an advocacy, it's a conversation, focusing on how scholars reason through the difficult questions of today, how evidence is weighed, how assumptions are tested, and how conclusions are reached. We ask everyone to engage in what's called the heterodox way, the HxA way, which is use evidence, being charitable, being intellectually humble, and being constructive. So if you'd like to learn more about heterodox, you can look up the FIU Heterodox Academy online and see our website, and we'd love you to join. So with that, let me introduce my friend and fellow Heterodox co-chair, Iqbal Akhtar, who is a professor in the Religious Studies Department. He's a Fulbright scholar and a co-founder of the Miami Interfaith, and he will introduce our speakers and the format.
All right, thank you so much for having us. We'll have two speakers on our panel today. Part of the reason why I'm interested in having the panel and having the discussion with regard to heterodox is I think the CAIR case is a really important case in terms of thinking about issues with regards to free speech here in the United States, in terms of how organizations are able to operate, what is their relationship to foreign governments and societies, and also it's an important case, I think, for the American Muslim community. And the question before us, essentially, is the state, both Florida and Texas, have designated the Council of American-Islamic Relations as a foreign terrorist organization, but it hasn't been designated at the national level. And so the question, a couple questions that we're trying to explore is a little bit more about this organization, thinking about what does this designation mean legally, statewide, what would it mean nationally, and also thinking about what is the relationship between organizations here in the United States and abroad as well, and the types of political and economic sort of relationships that exist, should exist or should not exist. And I think these are larger questions about the American Republic and kind of where we're at and where we're headed. So it touches on many of these things, and I'm very grateful to have two eminent scholars here to join us. Professor Howard Wasserman joined the College of Law in 2003. He teaches civil procedure, evidence, federal court, civil rights, and the First Amendment. He writes about the freedom of speech, the role of the procedure and jurisdiction in public law and civil rights litigation. He's also blogged, and he is a graduated magna cum laude from Northwestern University School of Law, where he was associate articles editor for the Law Review. He also clerked for Chief Judge James Giles of the United States District Court of the Eastern District of Pennsylvania, and Judge Roth of the Third Circuit Court of Appeals. He was also a visiting law professor at St. Louis University and Florida State University. So we're very honored to have Professor Wasserman join us. And our second speaker is Catherine Shahade, who is a lawyer based out of Miami at the law firm of Shahade Gianmour, and she heads the FDA practice. In addition to her legal practice and clients, she spends a lot of her time providing legal skills and knowledge to her community, and is passionate about Palestinian human rights and combating oppression of the Muslim community. Apart from her practice, she's also a writer and has published in many different outlets, including Witness and Consequence. So she does advocacy work for the community in addition to her legal practice. So we're very honored to have two legal perspectives, and the idea is that it's not a one side versus another side, but the idea is it's two of many sort of perspectives, and to have a conversation about the topics at hand today. So I'll start off with Professor Wasserman, if he can maybe give us his overall analysis of the CAIR case and what that means from a legal sort of perspective.
So what it appears is that both Governor DeSantis and Governor Abbott declared CAIR to be a foreign terrorist organization, and under state law that carries certain consequences, mainly that the state cannot enter into any contracts or agreements or do any business with an organization that holds that designation. What's different here is that so these statutes all piggyback, or typically piggyback off of the Secretary of State's designation of something as a foreign terrorist organization. So the way it normally works is Secretary of State would designate a foreign terrorist organization. That carries consequences with respect to the federal government, and then states have authorized their governments to essentially follow and implement those designations at the state level. The Secretary of State has the power under federal law to make these designations. There are certain procedural protections, excuse me, that are built into the designation. What's happened here is that both DeSantis and Abbott made the designation on their own, not following anything that the Secretary had already determined. And so we're in a kind of a no man's land for how these statutes are supposed to work, because if you take the foreign terrorism organization designation out, states generally cannot just decide that they refuse to contract or engage with organizations in retaliation for those organizations' speech. There are First Amendment limitations on that. States also cannot tell third-party organizations that they should not do business with a particular organization. So if you take the designation out, the state cannot say, we are not going to do any business or enter into any contracts with CAIR based on CAIR's expression and their advocacy. The state of Florida cannot tell third-party organizations like a law firm that you can't do any business or enter into any contracts with CAIR. All of that would violate the First Amendment. And so the question then becomes whether the state can independently make a determination that an entity is a foreign terrorist organization when the State Department has not made that designation. And so the lawsuit that CAIR has filed is arguing that, one, a state cannot make that determination on their own, that they can piggyback off of what the State Department says, but the federal government has the first and primary responsibility for deciding what is a terrorist organization, and the states can follow that, but they can't go on their own. And in the absence of that federal determination, then the consequences that the state is imposing on CAIR, no contracts with the state, no contracts for third parties who want to do business with CAIR, would violate CAIR's First Amendment rights.
Okay, very interesting. So is there a, it's being designated as a foreign terrorist organization, so is there some sort of criminal element, like sort of a criminal case that could also be made against the organization by the state?
I mean, if this, but the state's power to prosecute its laws is fairly limited. So if they could show that CAIR engaged or if they could show that CAIR engaged in some conduct that is unlawful under Florida law in Florida, then yeah, it could prosecute CAIR, but I haven't seen any record to indicate that CAIR has done any such thing.
And what is the basis that it's being designated as a foreign terrorist organization? Is there evidence that's been shown by the? Not that I've seen, and certainly nothing enough to. And I don't think they've shown any evidence to, according to CAIR's lawsuit, that the state never showed CAIR any information to suggest that. Okay, so from a legal perspective, what is, you feel that the state is probably at a weaker.
The state's at a weaker position because I'm not sure that the state can make the determination on their own. So even if we stipulate that CAIR has engaged in conduct that might get it designated as a foreign terrorist organization by the Secretary of State, were he inclined to do that, it's not clear that if the Secretary doesn't make that determination, that a governor of the state can.
Okay, so is this like kind of a states' rights issue as well?
States don't have rights. States have powers, okay. And states' powers are, in certain areas, are limited by the powers of the federal government. So if the federal government has primary responsibility for foreign affairs, and so there are cases not specifically dealing with this, but there's case law out there that a state cannot decide that it is going to boycott products from a foreign country where there's no, or impose sanctions on a foreign country where the federal government has not decided to impose sanctions. A state cannot enforce the immigration laws independent of what the federal government does. So the state couldn't decide that someone who is a lawful permanent resident is actually not a lawful permanent resident and therefore is present unlawfully. The state can't do that. Those are determinations to be made by the federal government.
So I have a question about terrorism specifically. So is terrorism then understood to be part of the federal government's purview with regards to foreign affairs?
I mean, there is a federal, not terrorism per se, there is a federal statute that defines foreign terrorist organization, and there are certain criteria that are necessary to be met, mostly involving around engaging in violence for purposes of effectuating societal change, or for causing fear within the general population. Florida does not have the power to, or I'm not sure Florida statutes allow the governor to do this. That's the open question. But something like designating something as a foreign terrorist organization, you are necessarily talking about some connection to some persons or entities overseas.
Right.
And so that creates a nexus to foreign affairs. And so I suppose a state could define terrorism, could define domestic terrorism, and enact some statutes accordingly. But since foreign terrorist organizations requires that foreign nexus, it pulls the federal government. It speaks to something that is primarily or exclusively the federal power.
And do you know of any laws for the? I mean, I'm interested also in the idea of domestic terrorism. Is that something that has been articulated in state law?
Not in state laws. There is a federal definition of domestic terrorist organization, but there are no actual legal consequences that follow from it in federal law. So there's a statute that defines it, but then there's no statute that imposes any consequences on domestic terrorist organizations. We've seen that with the supposed investigations for Antifa. There's a designation of Antifa, which is not actually an organization, as a domestic terrorist organization, but one, nobody knows what Antifa is, and two, no legal consequences attached to that designation. There are legal consequences to the foreign terrorist organization designation as a matter of federal law.
Okay. One of the things with CAIR as well is that it's kind of tied, there's an older case, the Holy Land Foundation charity case, after September 11th. And CAIR was named as an unindicted co-conspirator. What does that mean?
So an unindicted co-conspirator means that somebody was involved in the conduct of the criminal defendant, but for whatever reason was not indicted as part of the charges brought against that defendant.
Okay.
So it means that it might mean that there is enough evidence to charge, but we're unable to charge. It might mean that there's enough evidence to charge, but we choose not to charge, or it might mean that we don't have enough evidence to charge. So you were involved with this organization, but you yourself did not do anything that would rise to the level of a convictable criminal offense.
So the Florida's designation of FTO would be more consequential if the federal government then designates it as an FTO as well.
Sure. Well, yeah, because if they were designated as a federal FTO, then there's no question that the state has the power to impose those consequences, because the state isn't making an independent determination. It's just piggybacking off of what the federal government had done.
Okay, so now say that the federal government designates CAIR as an FTO. What are the practical consequences for the organization and its chapters in the United States?
Assuming due process is followed at the federal level, then that actually could, then the consequences that state law attempts to impose to that on that designation, no contracts or agreements with the state, those probably could be lawfully implemented.
Okay. Okay, so at a basically the organization can't operate or exist within the United States.
They can operate. They can operate and exist. They are going to have a problem. There are certain contracts they could not enter into with the state. So it's the consequences that Florida imposes is that Florida entities, Florida municipalities can't enter into a contract with CAIR. They can't do business with CAIR. That's the consequence that follows.
But if it happens nationally, then what does that mean?
So happening nationally just means the implications are the federal government won't do these things. And so the idea of these state laws was to impose state level consequences for the federal government's determination.
Okay, all right, but you could still operate within the United States, though?
You could operate, there are limitations that come on your operations,
Right.
certainly, but it doesn't render the organization illegal.
Okay.
If that's what you're.
Yeah, I think
You're,
that.
yeah,
right,
no,
right.
CAIR could still exist as a legal organization.
Okay,
The issue is just that they may have trouble finding government entities to do business with them.
right, okay. All right, great. Thank you, Professor. We can just move on to
Sure.
Catherine. and
Can
then
I
we
say
can-
one thing about that? I think also part of the problem then is you do have laws that prohibit material support for a designated terrorist organization. So if we're talking about fundraising, I mean, who's gonna give money then to an organization that is designated, certainly at the federal level, then even in the state, right? That would affect the ability to fundraise and maintain an organization. CAIR, at least as far as I know, CAIR Florida, you know, they provide legal services
Mhm.
for the community. They need money for that,
Sure.
right? They need filing fees to pay their attorneys, to, you know, pay for all of their just regular overhead. That's what would be in jeopardy as well.
And that's essentially the basis for CAIR's or part of CAIR's First Amendment claim, is that essentially because that consequence would be the triggering of the material support statute, then essentially Florida is jawboning, for example, lawyers to, you know, they could not do work for CAIR, they could not provide legal services for CAIR. And that's the basis of it. It's not only that you're imposing consequences on us, but you are threatening consequences on other people who may want to interact with us.
Okay. All right. Catherine, if you can tell us a little bit about how the American Muslim community or the community in Florida has reacted because CAIR is, of course, a very important organization for the American Muslim community. It's kind of one of the, we would say, kind of a legacy organization, and very important. It does both civil rights, but also political advocacy work as well. And so, can you tell us a little bit about CAIR and then its importance, and then for the American Muslim community or for the community in Florida, and what has been the response of the community here?
Yeah. So, like you said, a legacy organization, I would say CAIR is considered our main advocacy organization for Muslims, at least in Florida. So, and what they really do is provide support on the ground. So, you know, you have situations where people can't get, you know, religious accommodations to pray, or situations where someone gets arrested and their hijab gets ripped off, you know, like those kinds of things, or getting halal meals, you know, those kinds of things, but also, and what we've seen the last couple of years, protecting students' speech. So situations where you have students who, you know, are getting suspended from school or preventing organizations from existing on campuses. You know, CAIR as an organization on the ground has really stepped up and provided a lot of support for these communities who otherwise wouldn't maybe have the ability to pay for it, right? Because they're providing these services to them. So yeah, so then this kind of happening to CAIR, I would say it's been tough because, you know, on one hand, we know that based on the Florida law, the governor doesn't have the authority to make that designation. So, you know, what does it even mean, right? But then functionally, everyone's scared, right? So it does create that kind of chilling effect that we worry about in these types of situations, which is, you know, nobody wants to be the subject of an investigation themselves, right? Or lose their job or anything, right? So it's created a lot of confusion even amongst people who otherwise really support CAIR and their mission and what they do for the community, but you know, nobody wants to become the next target. So yeah.
I mean, one of the rationales, I think, I mean, again, this is one case of a larger series of issues, I think, that are sort of coming to a head in this case, I think. One of them is the idea that CAIR is representative of the ideology of the Muslim Brotherhood, and that so ideologically it's extreme, or it's somehow the work that it's doing is not in the interest of the United States or sort of the American people. What is your understanding of kind of CAIR's, not necessarily the civil rights part of it, but in terms of its like policy and advocacy part of its work?
Yeah, I would say, I mean, first, obviously, I don't work for CAIR, I'm not, you know, part of CAIR in that way, but from what I've seen what CAIR does, CAIR, like I said, they take calls from the community when something is going on, truly a civil rights organization that's, you know, geared towards Muslim issues. They don't ask, hey, are you Muslim? Hey, do you pray 5 times a day? You know, they support the community when they're in need. So that's what I've seen. When I hear something like this kind of charge from the governor, right, where it's like Muslim Brotherhood, I can tell you as a Muslim, I have no idea what the Muslim Brotherhood believes is, what, I don't know what they're suggesting that the belief or connection is. And I think a lot of people probably feel that way, that that's something we hear, that's something way back after 9/11 when you know, there were similar kind of push to discredit CAIR, same kind of things, and I think it's just, you know, kind of rearing its head again in the same type of political climate, unfortunately.
Okay, interesting.
I'll just say, I mean, this is the governor's pulled this move before because he did the same thing with Students for Justice in Palestine 2 years ago, when I think they did it by regulation that there can be no Students for Justice in Palestine chapters on campus, and they relied on a version of material support laws because SJP supposedly was getting all of its talking points from, it may have been the Muslim Brotherhood or some other foreign Islamic organization that, you know, they weren't saying SJP couldn't be on campus, it was, you know, no organizations that have a connection to foreign terrorist organizations, and that was basically how they tried to do this. So they've been playing this game for a couple of years.
Okay.
And what it is doing is kind of like stretching this idea, right, of material support. Like material support, what we would think of as lawyers means financial support, services, you know, those kind of things where you're actually providing something. Versus like ideological similarity, you know, or point of view, and those kinds of things where we're really talking about free speech.
So do you think, I mean, to what extent is then undergirding kind of what's happening is the Israel-Palestine issue?
I don't know that that's what's driving this. I can't purport to get into the governor's state of mind, and I think there's been a general anti-Islamic bias at work within the state. So whether this specifically ties to Israel-Palestine or just general bias, I don't know.
Okay.
But they're swimming in the same pool.
Okay, and so what would, I mean, in the past, I think when other religious minorities were targeted, you know, in American history, I mean, what are strategies that communities have used in order to secure their freedom of speech and kind of their rights?
Bring claims under the First, bring claims under the First Amendment. I mean, there's a long history of varying degrees of success of religious minorities suing when the state has attempted to restrict their free exercise of religion or their freedom of speech. I mean, a lot of the early important free speech precedents in the 40s and 50s were attempts to go after Jehovah's Witnesses. You know, now it's you know, now it's Muslim groups, and that they've been a target for, you know, a quarter century or more, but they've had a pretty good track record of litigating this. It just keeps coming up because there's so many avenues that states can try to come up with. So, you know, you've got the federal government has tools, and now the states have basically tried to get in on the action. And that's why you have a law like Florida's trying to enforce that really isn't strictly necessary.
So say we take, not this case, but just generally, I think then looking at this current configuration of the Supreme Court, how have, you know, what's been kind of the trend in terms of free speech and freedom of religion cases?
I mean, this has been a very speech protective court. It's been an extremely protective court for religious rights. Yeah, there's always the question of how principled individual justices are going to be, and whether that carries over when you're protecting not evangelical Christians, but minority religions. But I see no reason that certainly that they're going to abandon free speech.
Okay. Do you feel that it's pretty?
I mean, I think CAIR has a strong case here. I think because I don't think that the governor has the power that the state law power that he's asserting, and so now what you have is just sort of a naked, we're not going to contract with this organization because of their speech and advocacy, and you can't do that.
I think going forward, thinking about generally kind of I don't know, I mean, to what extent do you think then the general kind of political polarization in American society, I mean, we're seeing kind of all types of cases that are coming out with regards to particularly like the idea of freedom of speech, but, you know, to what extent do you feel that, you know, what type of consensus needs to exist in the United States to ensure sort of freedom of speech and freedom of religion, and do you feel that that consensus is framed, or do you feel that it's pretty well enshrined?
I mean, the consensus is always depend on whose. The consensus is always depend on whose ox is being gored. So everybody is all for free speech when the speech being protected is their favorite group, and then suddenly free speech runs out. You know, if you're talking about the public conversation, and then suddenly free speech runs out when, you know, somebody that I don't like. Or I don't agree with is speaking out on the street corner. So free speech is great until until there's these protests on campus that I don't agree with. So, you know, if you're looking at the public consensus as a whole, most people are really instrumental about how they treat free speech. The courts, hopefully, less so.
I mean, America, like, as a country, tends to be more, in terms of free speech among kind of the liberal democracies, tends to be more kind of absolutist, I think, as a society. I mean, one of the big challenges that we're seeing, you know, it's not exactly related to the CAIR case, but I think more generally thinking about freedom of speech is kind of the online platforms, right? Social media, and kind of the way that algorithms are sort of set up. I mean, what kind of challenges do you think social media and kind of online communication poses to existing free speech laws?
I mean, it depends. If we try to treat them as something completely new and try to do something completely different, then we start to get into trouble. I mean, the court did the right thing a couple of years ago with the social media moderation case, where they said moderation is like exercising editorial control. It is the platform engaging in moderation of the content that it is going to allow, and and that is protected free speech activity.
Okay. And what about hate speech? So how is hate speech dealt with in the law?
There's no actual recognized category of hate speech under the First Amendment. So there are categories of unprotected speech like incitement to unlawful conduct, like threats. The fact that speech is racist, anti-Islamic, anti-LGBTQ, anti-Semitic does not render that speech constitutionally unprotected. So if it's a threat, it could be an anti-Islamic threat, or if it's incitement, it could be anti-trans incitement. But what's making it unprotected is the fact that it's incitement and not the fact that it is hateful. So yeah, the fact that speech is offensive, obnoxious, hateful to some group does not render it constitutionally unprotected.
Okay. So I mean, there's nothing like, for instance, I think in Germany there are laws against like Holocaust denial and things like that. That would not those sorts of arguments would work here.
Absolutely not, nor should it.
Okay. So I think, I mean, in the larger sort of picture of, where the United States is again, how do you deal with anti-Semitism, Islamophobia, these sorts of things? What are the best, if the law is not really your best bet in terms of dealing with that, how do you then deal with hate that's sort of growing and developing in certain parts of the society?
You prohibit hateful conduct. You prohibit formal discriminatory actions. You prohibit the government from engaging in certain behavior, but I don't want to. The government should not engage in mind control. And so, if somebody wants to hate me because I'm Jewish or hate you because you're Muslim, I don't really want to give the government the power to try to stop that. Certainly don't want to give the government the power to arrest somebody or to prosecute somebody or to fire somebody because they don't like me because of my religion or any other characteristic. And so if people want to say, the premise of the First Amendment is, the premise of particularly the free speech clause, is that we don't want to give the government the power to decide what ideas are good or bad, because the government is not going to exercise that power well. And in all likelihood, the government is going to abuse that power. And so we don't want to give that to them. And if that means we have to tolerate offensive ideas when we walk across campus or the like, then that's something we deal with. And so what the CAIR case demonstrates is what we do care about, which is when the government steps in to try to restrict speech, that's when it becomes intolerable.
Okay. I know this is not your field of expertise, but it's a constitutional question also. With the current administration, the current president, it seems that there are a lot of, it seems kind of the traditional configuration, right, of powers that are kind of distributed between the executive, the legislative, and the judiciary. There seems to be much, over the last, couple of decades, there's been sort of a strengthening of the executive branch and kind of a weakening of the legislative branch. What impact does that have in terms of freedom of speech?
Maybe it's that it is easier to enact things that raise free speech problems because it is easier to make administrative regulations, or it's easier for the president to issue an executive order than if it had to go through the process in Congress. But I I'm not sure it makes that big a difference. Legislatures have shown themselves over the past 250 years as very capable of enacting legislation that offends the First Amendment. And so I don't think the president is uniquely capable. The president can do it faster, but I don't think the president or a governor acting unilaterally is uniquely likely to try to abridge free speech or free exercise of religion than the legislative body acting as a whole.
I was thinking if you're okay with it, we can just open it up to questions if people would be interested in. We have amazing panelists, and it'd be wonderful if anyone has questions to continue the conversation.
I wrote one down over here. I lost it. Some critics, and I'm thinking here about Azra Nomani sort of as the main one, have raised concerns about the early leadership in CAIR with connections to Islamist networks like Hamas. I wonder, why hasn't CAIR just come out in a highly visible, unambiguous public stance condemning Hamas? Wouldn't that maybe be a strategic choice to get out of any sort of terrorist organization designation? Is that a principled decision? Do you have any thoughts on why CAIR doesn't maybe distance themselves in that?
Yeah, and again, as I don't work for CAIR, right? But speaking as someone from the community, I would say a couple of things. This idea of distance yourself from these people that are terrorists, or you're presumed to be a terrorist, is a really offensive kind of ask. And it's only asked of this community. It's not asked of other communities. And I think if you try to maybe think of similar scenarios of other religious minorities, if you went to them and ask them, discredit the tropes about you, or well, we have to believe them. It's a very offensive kind of ask. So I think that's one thing. I think also just functionally, CAIR, like in this case, we're talking about CAIR Florida. There's CAIR Florida, there's National CAIR, there's all these different CAIRs. That's just functionally. But also, as a Muslim, it's never enough, right? So if I were to go, I disavow Hamas. Okay, but do you disavow the Muslim Brotherhood? And then next week is it this? Is it this? There's certain people that there's no level of being Muslim that they feel comfort with. So I think once you start, appeasing those kinds of ideas, it does become very dehumanizing, and something that I think an organization that does protect civil rights for a community, especially, needs to stand strong in the face of those kinds of asks, and those kinds of things that play into tropes against the community.
Other questions? John, yeah?
Hi. So we're talking a lot about the free speech aspect of this, and obviously, you're saying CAIR isn't involved in this kind of thing, and I don't know the background. But is there a scenario in which an organization with foreign funding funds the kind of protests, for example, that lead to violence and lead to destruction of property and lead to hate crimes? Is there a scenario in which that would make sense to then designate it a terrorist organization? Or is it across the board, every organization should be allowed those kind of freedoms?
Well, no, but there is criteria for when something crosses the line into being a foreign terrorist organization. So I'm not contesting that. I'm contesting that one, the governor has the standalone power to do it, and two, the showing has been made in this case, and I'm not sure that it has. There is a difference between agreeing with terrorist ideas and protesting in support of those ideas and promoting those ideas. That is constitutionally protected unless it rises to the level of sort of some immediate harm. There is a difference between that and what I think the federal statute requires to designate something as a foreign terrorist organization.
Right, but I do think, I mean, I'm not saying it's true or not, I don't know, but the argument is being made that foreign funding is going towards what it leads to acts of violence.
But I mean, what is leads to acts of violence
Like
mean? I mean, that's
like the campus stuff you were talking about earlier. It wasn't just people with an opinion that people didn't like. There was plenty of acts of violence that occurred. And so I think the argument, like I just quickly read the Texas thing, and the argument was that foreign funding through these organizations.
by itself. That I don't think that's that. By itself, no, that should not be enough. Because the mere fact that violence happened at the protests doesn't make the protests unlawful. A lot of the protests weren't violent. They weren't destructive of property. Or the destruction of property came about because of well, I mean, some of it came about when the police tried to break up the protests. Other came about when outside groups tried to break up the protests. So, this is not they funded a mob and the mob rioted. I don't think that reflects what happened on campus the last couple of years.
But if that were the case, because that's the argument being made, if that were the case, would
Well,
then
that's
this be
what I'm saying. If they can make if the Secretary of State could make the showing, then, but what you just described, they need more than that. So I guess I haven't seen the basis for the governor's determination, assuming he has the power to make the determination. But just on the facts we have, no, I don't think that would be enough.
So I think in terms of just thinking about, outside of kind of again, from the legal perspective, if you want to be able to create kind of or maintain, I would say, like, a society that believes in liberal values, for instance, right, and democratic liberal values, is there a legal strategy to be able to do that, or does that have to be completely sort of extrajudicial?
What do you mean by? But what do you mean by liberal values? Or what do you mean by maintaining liberal values?
So the idea of the rights of sort of all individuals, the idea that you would have like a common set of values, and definitely, I think anything that advocates sort of violence against sort of another group of people, right? So you're actually having some sort of civic community, right, in terms of the idea of democracy, for instance, as being sort of an important value. So these different sorts of values, are they purely through education, or is there some sort of like legal way that they are or would be enshrined in society?
Government can instantiate the values. I don't think government can stop illiberal speech, and government can stop illiberal behavior. But no, I don't think government can stop illiberal speech, or should have the power to stop illiberal speech. This is the paradox of liberalism that was described 75 years ago, that in the name of liberalism you have to allow a lot of expression that is illiberal and that undermines the liberal project. And yeah, that is the paradox. But I don't think you can achieve liberalism through illiberal means. Not true liberalism through illiberal means. So, shutting down illiberal speech is not going to be the answer.
I mean, one of the things that we're also seeing across kind of, let's say, the Western world is also a disenchantment with liberalism, and kind of in the liberal project as a whole. If that happens, I mean, do you think that, I mean, right now, again, the way that we've constructed the idea of free speech, could those boundaries also change?
I mean, we don't, yeah, probably. And certainly the less tolerant the society, the more restrictions that are going to be placed on free speech. The American approach isn't the only way to do it.
Right.
I think it's the best, but it's not the only way. There's certain things about American society that are unique and make our approach that makes sense that might not work in Germany. But but we're really sort of fighting at the margins. And if a society really starts restricting speech, or really starts being able to target groups or speakers with something like a designation of foreign terrorist organization, we go pretty far down the line away from liberalism.
So if we're, as a society, moving away from liberalism, I mean, where would we look in terms of legal cases that would, either in terms of decisions or in terms of the cases that are being litigated that can give us a sense, okay, our society is headed towards more sort of, curtailing of free speech and kind of liberalism? What are some of the warning signs or places that we would first see changes?
I think if CAIR loses this lawsuit, that's a big hint.
Okay.
I think if a lot of the, if a lot of what we're seeing on the streets now, if that goes unchecked, that's a pretty big hint.
Okay. All right, beautiful. Well, I'll let you guys, do you have any last statements or things that you would like to tell the audience, or anything you'd like to say?
Yeah.
All right, well, Dr. Shahade, Professor Wasserman, thank you so much for your time. We really appreciate it. It's been an honor and a pleasure. Thank you so much. I really appreciate it. Hopefully it was interesting. And
No, this was a lot of fun.
that's good, yeah. Thank you so much for coming. I really appreciate it. Yeah, it's just important for us to, I think it's an interesting case at the very least.
Yeah, I can't imagine it going anywhere. But again, I don't know what it is they think CAIR did.